Now, more of Illinois Rising, presented by the Illinois Policy Institute, the only show directly addressing the problems and solutions for Illinois. Now, from AM 560, here's Dan Proft.
We're back on Illinois Rising. Joe Kaiser filling in for Dan Proft with Hilary Gowins, Director of Content Strategy at the Illinois Policy Institute. You can also read her at the Huffington Post. Hilary, we were just talking to Cara Smith from the Cook County Sheriff's Office about cash bail reform. I want to get another perspective on this because when Cara was unpacking it, and she just went through all the both financial costs and the human element to it, it's such a serious problem that's affecting a lot of people that I think we need to unpack it a little bit more. So I bring on our friend David Kamek. David is a senior fellow at the Illinois Policy Institute, actually, and is an Aurora-based criminal defense attorney. David, thanks for joining us. Appreciate it.
Happy to be here.
So we're kind of unpacking this issue of bail reform among other key criminal justice reform efforts in the state. Why do you think bail reform is one in particular that people should be focused on?
Well, I think it's really an archaic system when, in order to get someone who has long-standing ties to the community, because they've lived here a long time, had a job, we have to have them post money to assure their appearance in court. That's not what's always done in federal court, and I think what we are seeing is that the counties are using the money from bail as a way to support their efforts when they don't want to fully fund it. The courthouse is what I'm talking about. I had a prosecutor tell me once, if you eliminated the keeping 10% of the bond, how are we going to pay for the court system? Which is not really the right answer.
So, David, you mentioned keeping the 10% of bond. Can you explain for listeners what you mean by that?
The way the Illinois law works now, if someone posts bond to get out of jail, or their family posts bond, let's say the judge holds them to post $25,000 on a serious felony or drug case, the court keeps to keep $2,500 for their effort in every county but Cook. Last year, Cook County was able to push through legislation where the maximum a person has to lose in Cook County is $100, whereas in the rest of the state is still the 10%. And Illinois did that, the 10% rule for posting bond, years ago in order to make sure that we didn't have bail bondsmen in Illinois, so that you didn't have to run to the bail bondsman to post the money, have them post the full amount. So Illinois set it up in the first attempt at reform, a lot saying you only have to put 10% of what the judge assigns as the bail bond. And that's just where it stopped. And I think more reform is necessary.
Sure. And so in your estimation, then, what are the appropriate reforms for this in particular? And then if bail reform did pass beyond that, what do you think would be the next thing?
I think what needs to be done is a couple of steps. One, I think the Cook County rule ought to apply statewide. There's no reason why the county should keep more than $100 for the trouble of taking someone's money and writing them a receipt. Already we've seen jails are charging fees to process the paperwork to get someone out of custody. What we're seeing is that counties and cities don't want to fully fund their operations and want to make the money on the backs of people charged with crimes, sometimes very innocent people charged with crimes. I think we start there. Secondly, I think the law ought to be changed, and I know the Policy Institute is working on it, where the preference for posting bond is an I-bond, a signature bond. And in those counties and locales where it's possible, have pretrial services submit a report to the judge saying, this is the gentleman or lady's criminal history, this is his ties to the community, this is what we think his chances of reoffending are. Give that information to the judge and allow him to decide whether money is required at all. If a person doesn't have a violent offense, he's got ties to the community, we shouldn't hold them.
So
make them pay money to get out.
David,
yes.
I want to take a step back because we're talking about reforms that are certainly necessary to the system, but there's also this cultural mindset that you have to think about and overcome when you want to tackle reforms like this? Some people don't see a problem with the current cash bail system. They're afraid that the idea of bail reform means putting bad guys back on the street. So how do you respond to that?
Well, not everyone charged with a crime is a bad guy initially. Secondly, they're not all guilty. And third, not all crimes are violent crimes. In nonviolent retail theft, a person driving with a suspended driver's license, person who writes a bad check, person that commits an act of criminal damage, perhaps. Those people are generally a danger to the community. Someone who breaks the neighbor's window. Those people have ties to the community. We just have to make sure that people who are presumed innocent, and the presumption remains with them, don't sit behind bars. I mean, it's easy for someone who's got money in their pocket to say, just throw a little money at the court system and let me out. But if you don't have money, if you're living paycheck to paycheck, that becomes a very big deal.
We're talking to David Kamek, who's a senior fellow at the Illinois Policy Institute, Aurora-based criminal defense attorney, and we were just talking about some solutions for nonviolent offenders. But while we kind of wrap up this discussion on bail reform, David, I'd like to get your take for our listeners to kind of understand this a little bit. Why does the bail system exist in the first place?
The whole point of bail, and it's in the statute, is to assure a person to appear in court. Someone who's been accused of a crime, what can we do to make sure he appears in court? Now, if you think about it, a few years ago we had some bail reform in traffic cases. The policeman used to keep your driver's license to make sure you appeared in court. They don't do that anymore. The policeman in some cases would make you post a small amount of bond if you didn't have your driver's license. They generally don't do that anymore, except in the more serious traffic offenses. The same should apply for low-level misdemeanors and felonies where this person has ties to the community. We don't need to make sure they appear in court because the consequences of not appearing in court are a warrant for your arrest with a significant bond because you have not complied with your obligations to the court system.
So, David,
the whole point.
Before we went on break, you were talking about things like I-bond, meaning a signature promising that you're going to appear in court. Can you just break down again why those are important alternatives for people who are not flight risks, for people who are not considered dangerous to the public?
Well, I think we sometimes view the world through the lens of fully employed, fully successful people. There are people that we know who live paycheck to paycheck. There are people that we know who struggle to pay their daycare bills, who struggle to pay the rent, and then to have them to come up with a $500, $1,000, $2,000 to get out of jail so they can go to work to support their family, it's backbreaking to them. The whole point of the system is to assure these people come to court to answer the accusation, because that's what it is. It's an accusation at the time of their arrest, and make sure they answer the accusation against them. And particularly when there are people who have been wrongfully accused or where the arrest was a little bit of a rush to judgment, we're punishing people who did no wrong.
Right, and then afterward, I mean, you're talking about people who might not have the means to work within the system. Afterwards, we're sometimes punishing them after they leave prison. Nearly half of ex-offenders in the state return to prison within 3 years, and that number dramatically drops if they have job opportunities. So the evidence is there. So I'm curious what you think is the way to approach this to get the political capital to tell lawmakers in Springfield or Chicago or on county boards to say, hey, the evidence is here about what we need to do to reform the system. It's not helping people. It's not helping our finances. It's clear. There's not really a gray area in what things need to be addressed on some of these issues. How do you kind of go about that and approach that and tell policymakers that these reforms are critical for both for helping people and for helping the finances of local and state government?
Well, I two things. I think we start with the fact that the legislature recognized that the citizens of Cook County shouldn't expect people posting bond to support the court system. The court system, they can only keep $100. Apply that statewide. I don't think it's really fair to suggest that a person without a lot of means in Cook County, it deserves a better break on staying out of jail or keeping their bond than a person in Kankakee or in Aurora or in Elgin or in Sycamore, DeKalb, or Joliet, a whole number of places where poor people exist. Poor people exist outside of Cook County. And we should not be stealing their money because they were accused of a crime, which later they were not convicted of, because it's not a fine. We're not imposing a fine. This is just their promise to appear in court. As for fully funding the court system, I wish I could give you the answer. I believe the history shows that Illinois has really never fully funded the probation system. For some reason, the criminal justice system, which processes more cases than in the other areas in the courthouse, there's more criminal cases in divorces or civil lawsuits.
Well, David,
for some reason,
I think, one of the points I want to close on as we wrap up our conversation with you, you made such a good point earlier. For people who live paycheck to paycheck, cash bail is an insurmountable obstacle. So cash bail is really ruining people's lives. Now that we're here in the holiday season, that's especially stark for a lot of families who are sitting around the dinner table without a loved one. If you can't afford to post bail before your trial, not only are you missing out on special days like this, you're likely to lose your job, your place to live, and your family life is sometimes irreparably damaged. So as we move forward in this conversation, I think it's important not only to think about the financial aspect of this failing system, which is significant, but also to think about the human capital that's lost because we are trapping people in a failed system.
I agree with you 100%, Hilary, and add to that the fact that the phone calls from the inmate to the family are the most expensive phone calls they're ever going to make, and a lot of jails are moving away from contact visits to video visits. I mean, it's harming the families. They're losing jobs. It's keeping people in the system that don't need to be, and those that do, much longer than they deserve.
Absolutely. David Kamek, thanks so much for your insights today. Always appreciate it. And have a Merry Christmas and Happy Holidays.
Thank you. To you both as well.